Good morning.
Good morning, Judge.
Good morning. Right. I can see one face. Mr. Mkambeni, I can see is there, but I don't see you. Ah, there we go. Right. Is there anyone else that I know? Well, I see Mr. Samuels is the attorney, not so?
Yes, he happens to be my instructing attorney, milady.
Okay, good. Well, good morning, gentlemen. I'm not sure if either of you has appeared before me previously.
Milady, I must say, it is indeed my first time.
Yeah, right. Mr. Eva, I'm not sure. Or is it Fouché, Mr. Fouché?
That's correct, my lady. Mr. Joubert is my leader in the matter, but I will be arguing the interlocutory application today.
Okay.
It's my first time before your ladyship,
Yes.
my name is Fouché at GVR.
Good. Well, I'm pleased to meet both of you.
Thank you.
I'm sorry, we have connectivity problems. I just hope this is not going to be a problem. If there's, you can't hear me or see me, just let me know. But I had a battle to connect a few minutes ago. Seems to be okay now. If not, I'll have to try and switch to another router, maybe my router. Yeah. So
well, it is as if it's not only your ladyship who had connectivity problems. I also had those because I ended up having to reboot altogether, go out of the machine altogether, then come back. See, even the page that is supposed to give me access to case lines shows that it's still busy reloading. I do not know what is happening.
Well, at the moment I can hear you, but your picture is frozen.
Well, I can see your ladyship's picture is not frozen. Mr. Fouché's picture is also not frozen. Yes, we do have these problems, but I'm meant to believe that it has everything to do with the Department of Communications switching off from 3G and 2G and also migrating us fully now to 4 and 5G. And some of the Centec towers are having problems keeping up with them.
Okay. All right. Well, I can hear you, but your picture's frozen again. And now I can't hear you.
Well, I was just quiet.
There we go.
Right. So,
all right,
so
good. I think we can get going. We're here now dealing with case number GP09 of 2019, a matter before the Special Tribunal. Today, we are busy with an application for separation in terms of Rule 33(4) of the High Court, the Uniform Rules of the High Court. And that application is being brought by the defendant, Mr. Lekabe. I think I'm going to refer to the plaintiff and defendant so that we don't get ourselves mixed up.
Yes, that's more than fine. Milady, if I may, I just want to, because I'm not the case line page is not yet up, but I'm resorting to the Word documents that are on my system, and I just gonna get to the heads of argument quickly.
Okay.
All right.
Let me just say that I don't have, so into documents on case lines, I don't have access. What I've done is done it the old-fashioned way, is just compile the documents, I've got summons, the pleas, the replication, and particularly with your 33(4) application. I've got the application with the founding affidavit, the answering affidavit, replying affidavit, and heads. So I think the best bet would be, rather than referring to case lines, just refer me to the document itself that you are dealing with.
Well, now your ladyship,
can you hear me?
Your ladyship was frozen, and in addition to being frozen, the voice, the audio, kept was choppy and disjointed. Even now, I
can't. Can you hear me now?
It's very true.
Yes, I'm. I've been having problems from the morning, and from yesterday, we've had the internet on and off. So I don't know how this is going to affect the rest of our hearing. Can you hear me now? I'm shaking your head. You can't.
Well, your ladyship,
are you not able to hear me?
The audio is very choppy and disjointed, and when your ladyship speaks, it's pretty much like we only get to hear about 5% of what your ladyship says. And currently, like your ladyship is also frozen. Yeah, your ladyship was frozen. Now the audio is completely gone.
I'm going to call our IT people. If you just give me a minute, I'm just going to call, just phone them to come through, and maybe they can assist. If you just, can you hear me?
Yes.
Now we can hear you, lady. Okay. I don't know. Can we maybe stand down for about 15 minutes? Let's just because so that maybe I also want to see whether my system will, especially the one that has case lines on it, because that will also give an indication as to whether we're limping or walking.
Yes. Well, I fortunately, Mr. Magoto has joined the hearing, so he's aware of the problem. But my secretary has just indicated to me that she's called the IT people in. So I think let's rather stand down for a bit and let them come and try and sort it out, and then we'll rejoin in about, it's 10 past now. Let's say at about 25 past.
In order, lady.
Thank you. Mr. Fouché, have you heard that?
I've heard that. Thank you, my lady. 25.
Good.
Thank you, my lady.
Thank you.
As your ladyship pleases.
But no one has started. The proceedings haven't started. All right. Okay.
Thank you.
Thanks.
Okay, so you must now record it on your phone.
I think I must record it.
Okay, everybody, but then, okay, everybody is muted.
Mm.
But I believe they will unmute when they start.
When they start, yes. So does that mean now I have to sit here the whole day?
Oh my word. Okay, I've put your mic on.
Yeah, definitely. No, you can mute. Please mute it.
You must.
Good morning.
That seems to be better, my lady.
Is it better?
Yes.
Let's just see if Mr. Mkambeni is with us.
Oh, I am.
Oh, you
I
are.
am.
Excellent. Good. Well, the pictures are clearer too, I can see. And
Yes.
yes,
Well, the sound, the audio is much
yes,
better.
much better for sure. I don't sound like an alien then trying to speak English.
No, it was not even a matter of sounding like an alien. It was a matter of the audio having vanished altogether. I guess it was caught up in warp speed somewhere.
Yeah, somewhere out in cyberspace. Yes, but I'm glad we're back again, and so we can resume the hearing.
Yes.
Just a bit of housekeeping. This is a separation application. I'm not sure how the two of you envisage taking this forward, because you're obviously going to argue the separation. But if you just tell me how you envisage taking it forward, and I'm not sure whether at this stage it's you want to go into the merits of those special pleas or not.
Milady, I've indicated in the practice note that I filed that perhaps we should use today for the special pleas, and then your ladyship, and also it would give your ladyship, if your ladyship desires to write a ruling for us to do so, and then because we've got the next 2 days, and I think the remaining 2 days would be sufficient for us to deal with the special pleas. So today, if we confine it to the separation, or to the argument in respect of the separation, it appears to work out fine, and then we then get a ruling either at the end of the day or tomorrow morning when we start, and then and then we move from there.
Mr. Fisher?
Yes, my lady. Madam Justice Mudiba indicated that today we can only argue the separation issue. And should the applicant or the defendant be successful in that it is up to your ladyship, or she indicated that it might be possible to then deal with the separated issues today and maybe on Friday. But that is obviously subject to your ladyship's approval and whether your ladyship needs some time in considering the application.
Well, I think that will probably be it. Just that, separating it means, or considering a separation application, you have to deal with the nature of the special pleas. So, I think we could do that without going into the actual merits of it at this stage. Good. Then we can move forward. And Mr. Mkambeni, if you'd like to kick off. I have read the heads, by the way. I've read all the papers. So it's really not necessary to repeat all of that. I think, the way I like to do it with matters such as this is hear what you want to highlight, or if there's anything you've changed or anything that you want amended in the heads, that's what we focus on. But I have read both your heads, both are comprehensive. Thank you for that. So it's not necessary to actually repeat everything that's in the heads.
Yes. Well, lady, if I may, obviously I stand by what is contained in the heads. That's the starting point. And then, of course, when one looks at the nature of the special pleas in question, and might I also add that even from a housekeeping perspective, we have, your ladyship will realize that in the heads, we make mention of claim C having prescribed as well. I've caused a Rule 2810 notice with a view to prescription regarding Claim C to be filed earlier today. And I've also asked that it be forwarded to Ms. Machitiso, who will probably pass it on to your ladyship during the course of the day, but our colleagues have it. Now, but coming back to what is on the papers, right? The nature of the special pleas. Lady, these special pleas are rather based on revolve around arguments that are rooted and grounded in law. And it's, of course, law vis-a-vis the factual position as expounded upon in the particulars of claim and from the combined summons which were issued on 5 December 2020. So
2019.
was it 2019? Oh, very well, very well. So the long and short of it, milady, is this. With regard to these special pleas, especially the administrative action one, that is a matter of law. It does not require viva voce evidence, lady, in any manner or form, and as a consequence thereof, the allegation and assertion in the answering affidavit to the effect that if the separation were to be granted, lady, the first plaintiff would be deprived of an opportunity of having all the issues ventilated properly, given the fact that they are still to gather certain evidentiary material. It's neither here nor there, and in other words, it's neither factually nor legally sustainable, because again, it's either we have a point in law with regard to that special plea of administrative action, or we don't.
Sorry, I'm sorry to interrupt you, Mr. Mkambeni. That is something for me that I could not find exactly what you mean when you say that's administrative action. Perhaps you'd just like to elaborate on that. I tried to see if I could pick that up from your founding affidavit, but it didn't come out too clearly. Apart from saying that it is administrative action that has not yet been set aside as legally invalid, I wasn't able to gain much more. Perhaps you can elaborate on that.
Well, it's quite simple, lady, and the legal position in that particular regard is very clear. All of the claims here, right, are based on Mr. Lekabe's conduct as the head in that state attorney's office in Johannesburg during the course of his tenure, and in that position, his functions were purely administrative by nature. And the wave of authority currently is that the minute an administrator, and that would also mean a successor in title or a superior officer, being anyone who would have the power to correct Mr. Lekabe's administrative acts, right, comes to a realization of the illegality thereof, lady. Then such an administrator must approach a court of law and have the administrative acts complained of with regard to legal validity set aside as such. And where there's a delay, then they must also, when approaching a court for a declarative legal invalidity, explain to the court why it took them as long as it did for them as administrators to stand up and seek a declarative legal invalidity, because a failure to do so would result in a state of affairs, as it has already happened here, where the administrator becomes financially bound to pay as a consequence of that so-called illegal administrative act. So that special plea will be argued on that, and it does not require viva voce evidence in any manner or form. So on what is contained in the particulars of claim alone, either we're out of the starting blocks or we're not. And put differently, either we're out of the starting blocks and past the finishing line, or we're not. It doesn't require viva voce evidence. It's on the papers. The ladyship can deal with it along those lines. And then, of course, lady, when it comes to the prescription special pleas, lady, what becomes very much apparent apparent in this particular instance is also the fact that the claims themselves are specific in the timelines with regard to the damage-causing event, as well as the time when the debt, the debt induced by the damages became due and payable. And with that being the case, it's easy for one to calculate the day from which, the time from which prescription ran. And also, these particulars of claim are reflective of the factual position in respect of the fact that neither the second nor the third plaintiff took any steps to interrupt prescription, lady, and that the combined summons were issued ex post facto prescription. And then, of course, one
Just give me a
has
moment.
also...
Sorry, give me a moment, please.
Yes.
Yes, you may continue, Mr. Mkambeni.
Right. And of course, then one has now, then one gets now to the locus standi and even the authority.
Oh, all right. Sorry. Just one moment. I see you're moving off the point of prescription. Just one question that I want to ask you on that. The respondents or the plaintiffs have raised the provisions of 12.3 of the Prescription Act, which says that prescription starts to run from the date that the debtor becomes known or the debt comes to the knowledge of the respondents or the plaintiffs in this matter. What is your response to that?
Well, lady, that does not help the cause. That does not help the cause in any manner or form, because there is the age-old rule, which is that in civil proceedings, one stands or falls by the very own papers. And if one has regard to claims D and E, right, amongst other things, one finds that where it is said that my client instructed Advocate Kgosisephuthabatho, it's actually claim B, to be specific, as well as claim C, to be specific, and claim D, where they say my client instructed Mr. Kgosisephuthabatho. They give specific dates in that regard, which specific dates indicate that the second plaintiff knew. Let me give an example with regard to claim C, right? It is said that on 1 December 2016, Mr. Kgosisephuthabatho considered the matter on instructions from my client, in spite of the fact that Lieutenant Colonel Songwani and Mr. Mafa Simon Moloi had instructed Kgotso Maile on 25 October 2016 not to settle the matter or even to separate the merits from quantum. And already that tells your ladyship that They knew that the matter was coming up, and come what may, they knew already by 1 December 2016.
No, I think that is where I read the summons differently, and perhaps you can tell me what your view is. I read it to mean, or to indicate that those dates, the specific dates that you've just referred to in each of those claims, came to their knowledge after the suspension of Mr. Lekabe, and that is what they are saying. That he was suspended, I think, in September 2018, if I'm not mistaken, and it was only subsequent to that suspension, when he was no longer in the office, that they were able to investigate, and this information came to hand. So I just want to hear what your view is on that, because that's what they are saying in the summons.
Lady, it can never be. It can never, ever be. Because, lady, the minute, they can't say they only got to know now. No.
No,
never.
not now. I'm saying 2018.
Yes, when I say now, I'm referring to 2018. They can't say that, lady. Because if the matter is considered, is settled for an amount of 1,021,440, roughly 2 years prior to 2018, lady, how do they account for that? That's a story, lady. As Leon Schuster puts it, they're telling us a story, and I'll explain why. These payments, these settlements, have to be gone through annually, and it's a notorious fact that this court can take judicial notice of, by the Auditor General, lady. So it means if they only got to know about it in 2018, when it came from the 2016-2017 financial year, they've not accounted to the Auditor General. It can never be. And then, of course, there is claim, let me just see, claim C, rather claim D, wherein they talk about the Mpiwe matter. And lady, what it boils down to there is this. They even mention payment being due on 26 June 2016. There, that makes it even worse. If payment is due, then it means they've paid. So it can never be, lady. They knew on the 26th, or rather on the 22nd of June 2016. They knew. And they did nothing. They did not go and rescind the Mpiwe judgment, or even approach a court of competent jurisdiction, as the SCA says in Kwasani Municipality versus Underberg. They did not, and they were supposed to have done that. And worst yet, lady, what strengthens these special pleas is the following. It cannot be good enough for them to say, to allege a corrupt relationship and say it was unlawful, without even asking your ladyship for a declarator of legal invalidity. They're not asking you that in the particulars of claim. If they were asking your ladyship that, you see, lady, then I would have an uphill battle in fighting here, because I would have had to fight the declarator of legal invalidity first, and then come up with a proper fight in respect of the claim. And they would have, from a PAJA point of view, PAJA and even Section 172 of the Constitution empowers your ladyship to give an order of just and equitable relief with regard to the damages. They could have done that, but they elected not to do that. They approached your ladyship on the wrong footing without having ensured that the requisite jurisdictional facts needed in order to achieve the goal were in place. And having failed to do so, then in as far as the special pleas are concerned,
sorry. Breaking up, I can't hear you.
And I saw your ladyship also froze a bit. Yes.
No, I'm not hearing you.
I think I can also see your ladyship also froze a bit. Am I audible, milady? Lady, am I audible? I see your ladyship has frozen. Your ladyship is frozen.
Hello, Mr. Mkameni? You're back.
I'm still here. I see your ladyship and I had lost each other. Your ladyship had frozen.
Yes. What happened is you said they did not ensure that the correct jurisdictional facts were present to achieve their goal, and that's as far as I
present in order to trigger off the exercise of Milady's discretion in their favor. And having failed to do so, Milady, on their version alone, Milady, they cannot get past the fact that these prescription began to run, and especially with regard to Claim D, prescription began to run on 22nd June 2016. So it does not help them in any manner or form that they issued summons 5 months and a week and 3 weeks later after prescription had run. So they're out on that one. And of course, when one takes, even if we struggle on prescription, lady, on that first one, the administrative action, lady, that one knocks each and every one of the claims they have out. And they've got to get past that, and I submit they'll never be able to get past that. And then, of course, there's also the locus standi and authority points that we've taken, because if one has regard to the manner in which the SIU Act and the State Liability Acts are cited in the initial paragraphs of the particulars of claim, authority has not been conferred on them to act on behalf of the first and second plaintiffs.
So are you saying that Section 5, sub 5 of the Tribunal Act does not give them that power?
It
deals with those proclamations, of course, that they referred to.
Yes. The way they've gone about, the way they've cited it there, they can't get out of the starting blocks, lady. And in the absence of the authority that they need, they should have the relevant sections and relevant sections of the proclamation that they should have cited in order to establish their authority to act. Now that they failed there, what they should have done, milady, was to, at the very least, obtain authorizing instruments from the second plaintiff and the third plaintiff.
Where is that a requirement?
Lady,
we're dealing with a tribunal matter, not a high court matter. But just tell me, where's that a requirement that they have to get like a power of attorney, an authorizing instrument?
Well, lady, it's not so much it's not so much a power of attorney or that, but rather a letter of authority ceding the right to claim on behalf of the first and second plaintiff. Because currently the first and second plaintiffs have been cited. However, as it is inherent in these matters, usually these two other plaintiffs, are usually inactive, and the lead is actually taken up by the first plaintiff. Now, if they've not complied with the tribunal's legislation, lady, then one would expect that because they've not complied with the tribunal's legislation, they would at least do something else to ensure that that gap is closed.
Well, isn't that gap closed by the insertion of that amendment to Rule 55? And I think, if I'm not mistaken, it was sometime in October. Just give me a minute. I think I can find that in the Act itself. Yes, it was enacted, or the amendment to 55 was done via the Judicial Matters Amendment Act 11 of 2012 on the 2nd of October 2012. And do you not think that that is exactly the purpose of why that section was amended? Simply because of the inaction on the part of government departments who have this problem, who do nothing. Therefore, the SIU was empowered in terms of Section 55 to do just that, is to institute the action in its own name or in the name of the relevant government department. I just want to hear your view on that.
Well, my submission in this particular regard, milady, is as follows. Our friends should have filed an amendment now that the legal position has changed. And our failure to file an amendment, milady.
I don't understand when you say an amendment of?
To reflect the fact that they would now be relying on the newly enacted position.
No, but at the time they issued summons in 2019, that enactment was already 5 years old, or more than 7 years old, because that amendment to 55 came into effect on the 2nd of October 2012. So hence, in the summons, they say they rely on the provisions of Section or Rule 55, or Section 55, sorry, of the Tribunal Act. So I'm not sure that I understand what you mean when you say there should be an amendment to what, to the summons.
That's precisely that, lady, to the summons. But at any rate, this takes us back to the projection that we made in the founding affidavit that even though we might struggle a bit, and even in the heads, that point is taken that even if we might struggle a bit with regard to the issue of authority, lady, on the other aspects, on the other special pleas, are good and strong. And those would ultimately be dispositive of the matter. So, and either way, even those very special pleas do not require viva voce evidence. So ultimately what it boils down to is this: if one looks at the test that your ladyship's brother, Mr. Justice Eckstein, referred to in the authority that I've cited in the heads, in the judgment of, let me just get the name right. It's Bulelani Pukane versus the Minister of Correctional Services on paragraph 23 of my head, lady. What it boils down to is this: are the issues that we raise capable, especially at this point in time in the proceedings, capable of resolving an issue that would ultimately not have to be revisited lady, either by way of appeal or otherwise, lady. And if the answer would be in the affirmative, lady, then I submit that we are on terra firma with regard to making out a proper case for the separation sought in this particular instance. Right? So, and then of course, there's the issue of, let me just see if I've gone through all of them in full. But more than anything else, what I've argued here was for emphasis purposes, lady. So on the basis of what we have on the papers and how the combined summons are, the issue of viva voce evidence out the window, it's off the table, right? And secondly, even the concern that your ladyship raised about them only becoming aware and prescription beginning to run when they become aware of that. Lady, I'm fully aware of and aware and cognizant of that argument, because it was even raised in the Makate Vodacom versus Makate matter in the Constitutional Court, lady. And the long and short of it here is that we can't venture into the realms of speculation and conjecture regarding when they got to know, because already the particulars of claim are self-explanatory in that.
Well, that's exactly the point I made earlier on. You see, that is where my concern stems from. Prescription, the issue of prescription is fact-driven. And how do we establish those facts? Because what is subjectively pleaded, or what is pleaded, is subjective. We only came to know after the 18th of September 2018. How does the court now on the papers establish it if you are disputing it and you're saying it's a story? Do I accept you and disbelieve them? And if I do, why do I do that? Or is this an issue, especially on the prescription, that can only be resolved by the way of evidence? And if I do that now, then I'm gonna need evidence now to say, yes, I should separate. But the same witnesses may well have to be called later on, and that's my concern: a duplication of procedures. It's an unnecessary waste of time, and it causes delays which are avoidable, and that's one of the main considerations of separation applications is convenience, not to one party but to all the parties as well as the tribunal.
Correct. Even if we fall on the prescription one, we still stand good and firm on the administrative action.
Okay.
And that one requires no viva voce evidence whatsoever, because what they should have done even there, they should have also done here and now in these proceedings. And they have not done it. So even if your ladyship would say, you can't touch prescription, and on the issue of authority, section 5, subsection 5 knocks you out altogether, what your ladyship cannot get past, and even our past this effect, that lady, the administrative action, special plea stands, lady, and that will not result in a duplication of anything.
Yes, well, I'm sure Mr. Fushi has a different view, but yes, thank you, Mr. Kameni. Are those your submissions?
Yes, and then if your ladyship is with us, lady, the issue of costs, then I would ask on behalf of Mr. Lekabe that the costs of this separation application be treated as costs in the adjudication of the special pleas. And if your ladyship is not inclined to separate, then they should stand over as costs in the main course. Then. Yes.
Thank you, Mr. Mkambeni. Are those your submissions?
Those are my submissions. So basically, even if the other ones are weak, the administrative law one does justify a separation.
Thank you,
it
Mr.
is sent as a special plea. Thank you, lady.
Thank you, Mr. Mkambeni. Mr. Fisher, are you still with us? I hope. There you
Thank
go.
you, my lady. Yes. No,
I see that it's nearly 11 o'clock. Should we take the tea adjournment now and then you gather your thoughts and you can do your presentation afterwards
yes, thank you, my lady.
at 11:30?
That's fine.
Thank you, Mr. Fisher. We'll take the tea adjournment now. Thank you. Right. Good morning, Mr. Forshire. Mr. Mkambeni, are you there?
I am, my lady.
Good. Mr. Mkambeni, I see is muted. I'm not sure if he's present. Mr. Mkambeni? Ah, there we go. We're all on board. Can you hear me? I can't hear you, Mr. Mkambeni. You muted?
Loud and clear.
There we go. Good. All right. Mr. Forshire, I think we're on resumption. It is your opportunity to now present your argument.
Thank you, my lady. My lady, I will more or less follow the chronology as is set out in our heads. Can I just inquire from your ladyship whether your ladyship also received our supplementary heads of argument?
I did yesterday morning, yes, I did.
Thank you, my lady. My lady, first of all, as your ladyship saw from our heads, the main question in respect of a separation is the convenience, not only for the parties, but also for the tribunal. Now, the only issues raised by the defendant to say that it will be convenient is that first he says that all these special pleas will be dispositive of the claims against him. The respondents submit that that is not correct, my lady, and I will take your ladyship through that, why we say that not all of them will be dispositive of this. And then the second and more important fact raised by the defendant is that it will be convenient because no viva voce evidence need to be adduced. However, my lady, it is the respondents or the plaintiff's view that in all of the special pleas, there will need to be evidence adduced, either documentary evidence or viva voce evidence, my lady. So if your ladyship finds that one or two of the special pleas cannot be dealt with on the papers only and evidence is necessary, then the plaintiffs submit to your ladyship, then it will not be convenient to hear any of the special pleas separately, because then one will start to nitpick some of the special pleas to be dealt with on the papers, some of them to be dealt with in the main action, and we submit that will not be convenient, my lady. In any event, on the defendant's argument, it would seem that we are in agreement if the special pleas cannot be dealt with on the papers and if viva voce evidence is necessary, then it will not be convenient. And then everything should be heard, or those where viva voce evidence are necessary should be dealt with in the main action, my lady. So the first special plea, my lady, was the non-joinder of Advocate Kaji from the
Kaji.
head. Yes, Kaji.
Oh, you froze out there for a bit, Mr. Forshire.
Sorry, my lady, am I back on air?
You're back. Yes, you're back.
Just want to see that I'm still on the stronger Wi-Fi. Yes, I am.
Yes. You're talking about Mr. Kaji, the non-joinder.
Yes, my lady. But it was already discussed between the parties. There will be a consolidation, or if it's not by agreement, there will be an application for consolidation of the action already instituted against him. And it would not seem that the defendant is serious in that special plea any longer at the moment, my lady. So I will not deal at length in that. But if there's a consolidation, then that special plea in any way will not be dealt or convenient to be dealt with separately, my lady. Then it's the misjoinder of the applicant or the defendant, my lady. Now, that submission can only be made by the defendant on the misinterpretation or the misunderstanding of the actual claim against Mr. Lekabe. He says in the heads of argument that he does not have a direct and substantial interest, and that the monies that was paid to either Mr. Kaji or to the plaintiffs in the actions against the Minister of Police will not be found with him, and the claim is therefore he doesn't have a direct and substantial interest. However, my lady, if one has regard to the actual claims as pleaded in the particulars of claim, that is not the cause of action. It's not claiming back the money, my lady. And if I can take your ladyship to paragraph 10.
I just need to stop you right there because you see, that's what I need clarity on. If you look at the claim in your particulars of claim, and I am looking at where is it? I'm trying to get to your particulars of claim, where you ask for relief, and there is, I mean, apart from saying that the defendant is indebted to the plaintiffs jointly and severally, you then claim the various pecuniary amounts, you know, the various money amounts. So I just need clarity there. When you say you're not claiming the money back from him, that was something I couldn't understand, because your particulars of claim is framed as though you want him to pay the money back.
Yes. My lady, the actual cause of action, if I can take your ladyship to paragraph 10, and I'll read it to your ladyship. It's not necessary to read with me, but paragraph 10 is dealing with claim A. Now, your ladyship will recall that claims A, B, C, and D are more or less the same.
Yes.
It is the claim is actually because the defendant instructed Mr. Kgosisephuthabatho to settle the matter between, in that instance, it was the Malole and the second plaintiff, and to pay the damages amount without any instruction or mandate from the second plaintiff to do so, and without the second plaintiff's knowledge. And then paragraph 11 continues, in respect of the cause of action, by instructing and causing the Malole matter to be settled in the aforesaid circumstances and amount, and without having obtained the required written authority from the SAPS to do so, and without knowledge of the second plaintiff, the defendant unlawfully, wrongfully, alternatively negligently, firstly, obligated funds of the second plaintiff in contravention with the Treasury regulation. Secondly, breached the provisions of the PFMA, the Public Finance Management Act, Section 45 thereof. He breached his aforesaid duty of care that he owed as a professional attorney to the second plaintiff, and he subverted the administration of justice. So that is the actual cause of action. Now, in just reading that, my lady, clearly the defendant has a direct and substantial interest in the matter. And what is more, your ladyship would recall, we are referring in our heads of argument to the Kunene and others versus Minister of Police matter in the SCA, and also the Minister of Police versus Mchali.
Give me the paragraph again, please, Mr. Fushi. Which paragraph of your heads?
That is footnote 5, my lady, and paragraph 16 of the heads of argument. Now, in the Kunene matter, that was a matter, my lady, where Mr. Lekabe and Mr. Kgosisephuthabatho also settled without any authority a matter with Mr. Kunene. In that instance, the payment was not yet made, and the plaintiffs in that, or the appellants, the applicants in that matter, being the Minister of Police, rescinded that judgment, my lady. So that was the difference between the Kunene matter and the current matters. The current matters was already paid out. The Kunene matter, it was stopped before there was a payment made to Mr. Kunene. But in that matter, my lady, the court already found the wrongfulness of Mr. Lekabe. And we say that is tantamount to already finding that there's a delict committed by Mr. Lekabe in these circumstances. What the court said there, so and that is the Kunene in the Supreme Court of Appeal, paragraph 36, my lady. It is said that the judge reasoned that Mr. Lekabe and Mr. Kgosisephuthabatho had subverted the administration of justice, they had acted contrary to the best interest of their client, the minister, and had denied him the opportunity to properly defend the matter or to settle it on a rational basis. Their conduct was inconsistent with the rule of law and the principle of legality. Consequently, the minister could not be bound by the compromises concocted by them. This is a case where the public interest demanded that the imperator of the court should not be given the orders that were made. And it continues, my lady, at paragraph 47 of the judgment to say the High Court thus correctly concluded that Mr. Lekabe did not act in good faith and was intent on subverting the law and his client's interests. Such fraudulent conduct is inimical to the rule of law and cannot form a legitimate basis for the minister's liability. No public servant has authority to subvert the constitutional principles on which the very idea of public confidence is founded. So that was already founded against Mr. Lekabe. And in respect of the misjoinder, clearly, referring to paragraph 11 and 10 of the particulars of claim, the plaintiffs would need to adduce evidence, my lady. And that can be then rebutted by the defendant in that issue. So also, the misjoinder issue cannot be dealt with on paper, my lady. Can only be dealt with once there's evidence before the court. So we say also the misjoinder issue will not be conveniently be dealt with separately, and that evidence is necessary.
Well, before you move off that point, the point that was raised by Mr. Mkambeni, I think, needs an answer. And he says that whatever Mr. Lekabe did amounted to administrative action. And that cannot be invalidated except by an order of court. And nothing else can flow from it until and unless you seek a declarator declaring the action to be invalid, legally invalid. What's your response to that?
My lady, can I address that while I will be dealing with the administrative action?
Oh, you're just doing the misjoinder now?
Yes, my lady.
All right, thank you.
Thank you, my lady. Alrighty, so that is for the misjoinder, which I cannot be dealt with separately. Then the special pleas of prescription, her ladyship would have noted that it's only a special plea of prescription in respect of claims D and E currently before the court. There's an attempt of an amendment this morning in terms of Rule 2810. It's our submission that there's no reason why the defendant should not bring us a proper notice of intention to amend its particulars of claim in terms of Rule 28. It gives the plaintiffs an opportunity to object thereto or to consider an objection thereto, so that claim C to be brought into the equation by way of that amendment this morning, my lady. We do not agree to that. We do not concede to that amendment. So currently before your ladyship's only claims D and E, and your ladyship canvassed that also with my learned friend in his argument. The respondents will adduce the evidence that they only became aware of the facts on which the delicts are premised or the cause of action are premised. So when the debt became due, after Mr. Lekabe was suspended in September 2018, then there was an investigation. And only during that investigation, so that's only after September 2018, they became aware of the facts. Now, my learned friend argued that the payments were already made in 2016, and that is when the debt arose. But my lady, those facts could only have been pleaded subsequent to the investigation. Those facts were only seen during the investigation, and that is why the particulars of claim was drafted. Your ladyship would have seen in the affidavit, the answering affidavit in this application, the submission is made that Mr. Lekabe concealed what was happening within the office while he was the head of the office, and therefore these facts only came to the knowledge of the plaintiffs subsequent to the investigation, and that was only after September 2018. Now, my lady, with respect, the respondents or the defendant cannot prevent the plaintiffs from adducing this evidence. It is plain that this cannot be dealt with on the papers only, my lady. And with respect to your ladyship, correctly referred there to, this is not a question of law, this is a question of fact, as to when did they become aware of the facts. And your ladyship saw in our heads of argument, we're referring to section 12, sub 3 of the Prescription Act, and we cannot be prevented from adducing that evidence with respect, my lady. So in respect of all this prescription special pleas, we submit that it can only be dealt with in evidence, and that it cannot be dealt with on paper, and certainly not convenient to be dealt with separately from the main action. And your ladyship saw the submissions made in the answering affidavit that this will only bring about the duplication of witnesses, duplication of evidence, and a multiplicity of the evidence to be adduced, and certainly not convenient, my lady. Then the next special plea taken by the defendant is the issue of the lack of averments to sustain an action in respect of paragraphs 38 and 39. Now,
he did not, Mr. Kambeni did not address me on it. I think he just highlighted some, but I accept that you need to address on it because it's in the papers.
Yeah, it's in his head. Yes, correct, my lady. So, well, firstly, just by the language of that special plea, your ladyship will note it's actually an exception. The defendant already took exception to the plaintiff's particulars of claim on a previous occasion. That was unsuccessful, and the exception was dismissed by Madam Justice Sewendu previously. So I'm not sure how this can be couched as a special plea in any event, my lady. So an exception you take against the whole of a pleading. You don't take an exception against one or two paragraphs. Now, the same with this, my lady. You cannot go to two paragraphs in a particulars of claim and say that it does not sustain a cause of action. Because many paragraphs would not sustain a cause of action because you plead a pleading in a whole, as a whole, my lady. So, in any event, this is in respect of claim E. Now, claim E is the claim where the monies were paid over to Advocate Kaji on the authority of Mr. Lekabe when he was the head of the office of the State Attorney Johannesburg. He had the authority to appoint counsel, and obviously the authority stems from him to also pay counsel then in that respect. So we submit that all those claims from 2013, that's the paragraph 38 and 39, up until 2018, when the last payments were made to Mr. Kaji, should be dealt with as a whole, my lady. So you cannot nitpick a certain portion of claim E to say there's no cause of action. That must be dealt with together with all the other facts pleaded against Mr. Lekabe in the claim because of the monies paid to Mr. Kaji. And obviously, evidence need to be adduced in all of those instances, all of those years, all of the payments. The allegations are pleaded that it is double payments, it's overreaching. Without a doubt, evidence would need to be adduced, and this cannot be dealt with separately and cannot be dealt with on the paper, certainly, my lady. So also that special plea should be dealt with together with the main action. Then it's the question of the administrative action, my lady. Now, the defendant makes a conclusion that the actions are administrative actions. We're not quite sure what he's referring to. And the plaintiffs would need evidence in respect of the so-called administrative actions. Just to take your ladyship to the Promotion of Administrative Justice Act 3 of 2000, there it defines administrative action. And it defines it as administrative action means any decision taken or any failure to take a decision by an organ of state when sub exercising a power in terms of the constitution or provincial constitution, or sub exercising a public power or performing a public function in terms of legislation, or a natural or juristic person other than an organ of state when exercising a public power or performing a public function in terms of an empowering provision, and this is important, which adversely affects the rights of any person and which has a direct external legal effect but does not include, and then there's a list of exclusions, my lady. So for that, evidence is needed to place it within the realm of, that is the definition of administrative action. To go further, my lady, a decision is defined in the PAIA Act as means a decision of an administrative nature made, proposed to be made, or required to be made, as the case may be, under an empowering provision, including a decision relating to, and then there's a list of decisions. But what is important, it is a decision of an administrative nature. Now, the Supreme Court of Appeal, my lady, says that conduct of an administrative nature was generally understood as that of the bureaucracy in carrying out the daily functions of the state, and which necessarily involve the application of policy. Now, bureaucracy, my lady, if one has regard to that in the Oxford Dictionary, it says bureaucracy is
Before you go on, sorry, was that referred to in your heads?
Sorry, my lady, I did not refer to this in my head. If I can give your ladyship the citation, it's the trustees for the time being of legacy body corporate,
yes,
versus BAE estates and escapes,
yes,
PTY, and that is at in the law reports at 2022 volume.
Sorry, 2022 volume.
Yeah, 2022 volume 1, SA 424. And that's the Supreme Court of Appeal, and specifically referring to paragraphs 14, 15, 18, and 19, my lady.
Thank you.
And bureaucracy is defined in the Oxford language as a system of government in which most of the important decisions are taken by state officials rather than the elected representatives. So that's a system of government. Now, my lady, obviously, one would need evidence in respect of what would this so-called system of government decision taken by the defendant be. Plaintiffs are in the dark, and we submit that without adducing evidence, this special plea can also not be dealt with conveniently. Now, ladyship requested me earlier to answer in respect of the argument of Mr. Lekabe, but that whole argument falls away if it is not an administrative action. And the plaintiffs in their heads and in the affidavit tells your ladyship that it does not fit the bill of administrative action as defined in the PAJA Act, my lady. So then it is clearly not necessary to follow the PAJA Act in setting aside the so-called administrative actions. But the main argument in respect hereof for purposes of the separation issue is, firstly, it cannot be dealt with separately without adducing evidence, then it's not convenient. And secondly, should your ladyship be of the view that any of the other matters cannot be conveniently be dealt with separately because we need to adduce evidence, or the parties needs to adduce evidence, then this also should be dealt with rather with the main action, my lady, and not to start nitpicking between various special pleas that can or cannot be dealt with separately. Certainly that will not be convenient, my lady. If that answers your ladyship's question.
It does, yes.
Thank you, my lady. My lady, and then the only other special plea that remains is the lack of authority or the lack of locus standi. Now, the normal way in dealing with the attack of somebody's authority to act on behalf of somebody is in terms of Rule 7. Now, Rule 7 says that if there is such a query in respect of the authority of someone to act on behalf of, then the matter should be stayed until that party can satisfy the court or the tribunal in this instance that it does have the necessary authority. So firstly, it's now brought by way of a special plea. So what is required from the plaintiffs is to adduce some evidence on the own argument of the defendant this morning. He actually argued and told your ladyship we had to bring an authority instrument. We had to show an authority instrument, but that is done in trials by way of discovery. The parties are still busy with discovery, my lady. So unless it is the defendant's view that the matter should be stayed until that is done, but then you do a normal Rule 7 notice. And then everything is stayed until you can satisfy the court that you do have the necessary authority to act on that person's behalf. But it is brought as a special plea, so it can only be adduced, evidence can only be adduced at trial.
Well, the way I understand Mr. Mkambeni's argument is that the way you cite the legal provisions in paragraph 2 of your particulars of claim is not adequate. And that's what I understood him to say, that you should have attached maybe a letter of authority.
Well, that you don't do to a pleading, my lady, maybe to an affidavit because the affidavit is already the evidence. But to a pleading, you plead only the facta probanda. And the documents or the viva voce evidence will be the facta probantia, which you can bring in by way of evidence. In any event, my lady, and with respect, I agree with your ladyship's view of Section 5.5 of the Section 5 sub 5 of the SIU Act, that the first plaintiff is permitted to act on behalf of the second and third by way of legislation. That's going to the merits of the matter, my lady. But in any event, on the argument of the defendant is that we still need to adduce some evidence. So clearly, it's not convenient to deal with this separately. To, in a piecemeal manner, bring evidence to the court or the tribunal to prove certain aspects of the plaintiff's claim, my lady. So also this cannot be dealt with separately. So, in a nutshell, my lady, and in conclusion, the defendant argued at the end of his argument that it would seem that this administrative action special plea would be his strong point when and that is the one special plea that should be dealt with separately. Plaintiffs do not agree, my lady. If there's only one special plea to be dealt with separately, it will not be convenient to do so. If all of the others should stand over to be dealt with at the trial, so should the administrative action question, my lady. And in any event, there's evidence necessary for that, so it can't be dealt with separately. In respect of costs, my lady, I would submit that this application is a separate application. It should be dismissed, and the costs should follow the event. The defendant should be ordered to pay the costs, and such costs to be cost of to counsel. Your ladies will see that my leader, Mr. Joubert, is on the platform today. I'm only arguing. We both drafted the heads of argument and prepared for argument today. So I would move for an order that the application be dismissed and that the defendant be ordered to pay the costs, including costs of to counsel. Unless there's anything else that I can address your ladyship on, those are my submissions, my lady.
Just looking quickly if there's something I need you to address. No, not for the purposes of this application. What queries I have actually go to the merits.
Thank you, my lady.
Thank you. Reply, Mr. Mkambeni?
Indeed so. Lady, I'm going to start first by addressing the issue of administrative action. And with the greatest of respect to my colleagues, they seem to have gotten it wrong, because the definition of administrative action is not only to be found in Pasha, but it's found in Section 239 of the Constitution, read with Section 1 of Pasha. And if one has regard to the position that my client held, my client was an administrator, it doesn't require any additional evidence, as my colleague wants to suggest. And if one has regard to the cases I've cited in the heads, specifically Underberg, lady, the Kwasani municipality case, which is an SEA case, and I've also cited a constitutional court case, lady, which are unanimous and ad idem on the fact that the minute there is a legality problem with an administrative act, it behoves the administrator to stand up without delay and approach a court with competent jurisdiction. In Kasu, that would also include the tribunal, lady, with a view to seeking a declarator of constitutional, rather legal invalidity, lady. And then flowing from that, the damages could follow, if any. But now,
just to make the point, Mr. Mkambeni, these extended arguments now were not, no basis was laid for that, apart from the bold allegation that whatever Mr. Lekabe did was administrative action. The court was left wondering on what basis this assertion was made. I'm hearing now that you say one's got to look not only at the definition in Paja, we've got to look at the Constitution and so on, that he's an administrator. So for the purposes of this application, as I said, I'm hearing that now. The defendants, the plaintiffs rather, have not had an opportunity to grapple with that and address me on that.
No, but with the greatest of respect, milady, they have. And I'll explain why I say that.
Mm-hmm.
The special plea itself makes it clear that this is an administrative act. And the minute you have a special plea that tells the plaintiffs that they're dealing with an administrative act, milady, it is tried, and it goes without saying that they've got to look at they've got to expect an argument of this nature, milady. It cannot be said that we didn't lay a basis for that. That is something wherein I cannot agree with your leadership in this on. Furthermore, my lady, the minute one has the minute administrative action comes into the picture, my lady, in line with stare decisis, my lady, your ladyship is bound to abide, not to deviate from what the SCA and the Constitutional Court have said. And in Tassima, in the Constitutional Court judgment of Tassima, and it's unfortunate, I thought of it now, as Mr. Fushia was arguing. In Tassima, at paragraphs 87
Is that in your
82.
head? Is that
It's not in the heads. It's
Can you
not
give
in
me
the
the
heads.
citation?
I can give the full citation, lady. It's Department of Transport and Others versus Tasima. Tasima spelled Tasima, Pty Ltd.
Mm-hmm.
Right. 2017.
Yes.
One in brackets.
Sorry, what volume?
Volume 1.
Mm-hmm. Yes.
BCLR, Butterworth's Constitutional Law Reports.
Mm-hmm.
At page 1.
Yes.
CC, and then of course the South African Law Report citation is 2017, volume 2.
Mm-hmm.
South African Law Reports, page 622,
Mm-hmm.
and capital letter CC, Constitutional Court.
And you're reading from paragraph?
Milady, specifically at basically what the court has done in basically repeating and restating the position taken up in Underberg, which I've referred to in the heads, lady, which, and the position in Underberg is as follows, lady, as in line with what Judge Trevor Govan has written for that unanimous court. If and when an administrator realizes that there is a legality problem with an administrative act, an administrator cannot, like a layperson acting with the administration, bring a review. Hence, the administrator must go to court and seek a declarative legal invalidity in order to set aside that unlawful, that illegality. And because if they do not do that, lady, what the problem that results is that unlawful administrative act, unlawful as it might be, might ultimately become insulated. And if the administrator is late in approaching a court of law or even this tribunal, lady, in either the action or the application they bring with a view to setting aside that administrative act, they must also seek an indulgence in the form of condonation, explaining why it took them as long as it has to ultimately stand up and approach this honorable court. And because if they've not done that, then I'll take it by saying, but I'll even juxtapose it by saying, if one reasons it by analogy, when a layperson or an outsider brings a review, they've got 180 days, right? If they bring it outside the 180 days, then Section 7 requires them to apply for condonation. Because if they don't apply for condonation, then the court does not have a review in front of it because a legal requirement is missing there. So basically, what the court said, the SCA said there, is that when you approach a court late, explain to the court why you are late, and that involves a public policy decision that the court would have to make in granting that indulgence, because the indulgence sought is not there to be had. There must be a reasonable explanation. Your ladyship has not been given the papers as they stand, right? Do not have a declarative of legal invalidity in them. They do not even have an explanation as to why they're only coming to court now. Instead, what your ladyship has been served with is an argument to the effect that in the Kunene matter, payment had not yet taken place. But then in the other claims in question here, payment had already taken place. Thus, taking us back to the question your ladyship asked me initially, about them only getting to know in 2018, and my response being that it could never be, because payment should have occurred just under 2 years prior to 2018, the time they talk about. So prescription began to run there, but we're not yet at prescription. We're still here at administrative action. From a section 239 perspective of the Constitution, read with section 1 of Paja, milady, and then seen in the prism, through the prism of Tassima and also Underberg, milady. The jurisdictional facts needed for your ladyship to trigger, for your ladyship's discretionary power to be triggered in favor of dismissing this application for a separation have not been met, lady. And it cannot be said that by kicking this administrative action special plea for touchdown, by kicking the can down the road, and as far as this is concerned, your ladyship is basically denying the first plaintiff of an opportunity to adduce evidence, because at the issue of evidence, viva voce evidence, does not even, as Professor Marinus Vichers of UNISA used to put it, it does not.
Sorry, Mr. Mkambeni, you're frozen out again. I can't hear you. Your picture's frozen. You're back on, but I missed a whole chunk of what you were saying. Your picture was frozen and I couldn't hear you either. You were saying something about Professor Marius Vickers.
Yes, what Marinus Vickers said was that when one looks at the issue of evidence as suggested by Mr. Fouchier, milady, the issue of evidence does not come into the picture. It is either the claim is based on administrative action or not, milady. And the position my client held fits squarely within that bureaucracy, that bureaucratic definition your ladyship was being given. So there's no need for evidence to come with a view to coming and redesigning the wheel here. No. My client was an administrator, and in the decentralized and the deconcentrated administrative law relationship, when he was suspended, milady, they ought to have done something then. But it's not only that. In terms of their own papers, the second plaintiff, milady, knew when money left the second plaintiff with a view to paying these claims. Because according to them, by their own version, milady, they had not given instructions for the settlements that ultimately ensued. So if that is the case, if they had not given instructions, milady, why did they pay instead of rescinding? One. And secondly, milady, why did they sit back and do nothing instead of approaching this honorable court? And it can't be an excuse that certain government departments are lethargic, milady, because then it makes a mockery of the full bench decision, wherein, in the matter of rather Harris versus Absa Bank, trading as Volkskas, 2006, volume 4, South African Law Report 521, and rather 524, and specifically at 527, E to F, wherein Moseneke J, together with Bertelsmann and Derksen, said the following about willful default. He said this, and this comes into the logic by analogy. Where a party receives process, knowing what they need to do in order to ward off judgment by default from being taken, the party sits back, folds their arms, and does nothing. And judgment by default actually materializes. Such a party can't be heard to complain. And if they were to come to court seeking rescission, they would lose. Now let us reason it by analogy. What do we have here, milady? We have the second plaintiff, right? In claim.
I don't want you to re-argue the whole matter again. I just wanted you to respond to what Mr. Fouchier is saying.
Right. Responding precisely to what Mr. Fouchier says. Payment happened in respect of claim. Let's take claim D. Payment happened when? 22 June 2016. If payment happened then, milady, it cannot be said that they did not know. And if they sat back and did nothing, milady, then it goes without saying that they willfully defaulted in standing up, going to the High Court with a view to setting aside the administrative act that resulted in that payment happening, lady. And if they have willfully defaulted, lady, then what comes into sharp focus is the following. Even if they are to try and bring a rescission of judgment application now in respect of claim D, they would fail. Because if one takes a cue from what Judge Govan said on behalf of a unanimous court in the SCA in Underberg, by sitting back and doing nothing, they've basically insulated the claim from being assailable. They've basically let the horse out of the stable. And if they've let the horse out of the stable, what are we settled with? This is basically a clear case of looking for a fall guy here. But again, that does not change the fact that from an administrative law perspective, no further evidence is required. Section 239 of the Constitution, read with Section 1 of Paja is there. The two judgments of the Constitutional Court, inclusive of the third one, the third Constitutional Court judgment that I referred to in the heads, are there to regulate the legal position. And all these claims, lady, fall on account of the fact that they are administrative acts. So if your ladyship, either way, if your ladyship deals with the special plea on administrative action, lady, not only are we out of the starting blocks, but we're past the finishing line. And then, of course, there is the issue, and of course, what does it do with regard to convenience? Then the issue that then it becomes convenient for your ladyship to grant the separation in this regard. And lady, then I've also had an opportunity to look at Section 5, subsection 5, which your ladyship debated, your ladyship and I earlier on debated. And my lady, I'm standing by my earlier submission that they should have put forward an authorizing instrument, lady, if they were going to plead in the particulars of claim as they have. And it's not good enough to say of Mr. Fouchier to say that this is something that could have been, that they were still going to do in discovery, lady, or through discovery, or that this is an issue to be resolved by means of Rule 7. There's a difference here. There's a difference. We're not challenging the authority to basically, we're not saying they're not competent to stand up in court. All we're saying is the fact that the first respondent, even if, as Section 5, subsection 5 says, it may act on behalf of the second and third plaintiffs, lady. Are they even authorized to act in this regard? Because, again, the second and third plaintiffs are here, but they're not active in any manner or form. It is the only party that's active is the first plaintiff. And if so, milady, then all issues relating to the representative capacity here on behalf of the second and third plaintiff, lady, would have to be resolved properly by means of an authorizing instrument. It starts and ends there. And then, of course, the issue of the misjoined, before I go to the misjoined, and if that is indeed so, milady, with regard to the excuse me. Excuse me.
Mm-hmm.
Lady, if indeed it is as such with regard to this issue of authority that we've taken regarding, and which revolves also around that Section 5, subsection 5 debate your ladyship and I have had. Lady, I submit that it is not as clear-cut and dry as my colleague wants to make it out to be. And this is not an issue that would require evidence. Because, again, we go back to what? The age-old doctrine that at civil law, one stands or falls by the papers. That's the long and short of it. That's where it starts. So, on that score alone, this is still an aspect where the issue of convenience requires that your ladyship indeed come back with a separation. And then, of course, milady, the issue of the misjoinder. Milady, I've never heard something as preposterous as this, because my colleague says, just because the SCA found that there were certain forms of misconduct in the matter of Kunene, he says that it means that delicts of the same nature or species were committed even in this matter. Lady, if that logic, that thread of logic is to be sustained, then it would mean that the plaintiffs are absolved of the burden of proof on a balance of probabilities. And it can never be. Kunene is a matter on its own, lady, with its own merits and demerits. And these current matters, lady, are matters on their own, lady, and must be treated on their own merits and demerits. And of course, in Kunene, lady, the rescission was granted there. At least they did the correct thing. But now, in this instance, unlike in Kunene, milady, they have not done the correct thing. So, again, your ladyship is being asked to apply a standard where the SIU has done the correct thing to a state of affairs wherein the SIU has dismally failed to do the correct thing, milady. And then the common refrain which they hide behind is, oh, we are going to need evidence, be it documentary or viva voce. No. these are questions of law. And once these special pleas are out of the way, let's say the tribunal is not with us, then we climb into the merits. We don't come back to, we don't revisit these things. We climb into the merits of the matter. So it cannot be that our friends on behalf of the plaintiffs are going all out to avoid dealing with these special pleas head on. And given the fact that, if I remember correctly, during the pre-trial that was held in August last year, your ladyship's sister, Madam Justice Siwendu, impressed upon me quite robustly that the tribunal adopts a robust approach. And I was expecting a robust. So we function on the basis that the tribunal adopts a robust approach to these things. That is why we've raised these special pleas. So, and it cannot be said that we're nitpicking. And then, of course, so on that score alone, lady, I would submit that we are good to go. And then there's the non-joinder and the misjoinder issue. Lady, in the heads, I've said that even if the non-joinder issue has been cured by the fact that they've now gone and instituted action against Mr. Kaji, right? The misjoinder issue has not been resolved at all. Because, again, my client has neither a direct nor a substantial interest. And in this regard, I've referred to the judgment of your ladyship's brother, Mr. Justice Sadiwala, the Sono judgment, lady, wherein he also dealt with what Judge Harms basically set out as being a direct and substantial interest sufficient to warrant movement against my client by the plaintiff. It's not good enough to say what the findings.
Mr. Mkambeni, can you hear me? You've frozen out again.
Even if I'm frozen, I can hear your lady
okay.
Loud and clear.
Yes, no, you the last bit after you said you referred in your heads to Judge Sadiwala's judgment, and he refers to the Harum's judgment, and then I didn't hear any more.
Yes, basically, he refers to what Judge Harums in his loose leaf on civil procedure in the Superior Court deals with regard to the misjoinder and the misjoinder aspect. And it cannot be good enough, milady, for Mr. Fouchier to basically attempt to circumvent the question your ladyship asked him about how they have set up the pleadings in the POC with regard to the pecuniary element there, lady. Because again, he tried to circumvent it by referring to the Kunene matter, which doesn't help them, lady, because in actual fact, Kunene works against the argument Mr. Fouchier sought to make, and it works against it in the following manner. Again, in Kunene, they successfully rescinded the judgment and payment before payment could be made. In the current matters, milady, the money is gone. The money has been let out of the stable, milady. And with the money having been let out of the stable, milady, it goes without saying that my client is not the end point, milady. They can recover the money from the plaintiffs who have been paid, and they should have done it a long time ago. Or they could recover it from Mr. Kaji. And again, what militates against them now, going against the lay plaintiffs in those matters, in those respective matters, is again what Judge Trevor Govan said. You sit back, you do nothing for too long. You insulate that wrongful and illegal act. You insulate it. And the second plaintiff, by means of its supine approach, has done precisely that, because they knew when the money was paid. It was paid out of instructions that they had not rubber stamped. And if it didn't carry the rubber stamp, then they should have stood up and fought before the money got paid. Or if the money had gotten paid, they should have stood up and fought there and then. And then, of course, your ladyship is even told that, so basically on the misjoinder, lady, before I even go to the prescription, because I wanted to finish off with prescription. So on the misjoinder, lady, no additional evidence is required. The misjoinder can be resolved by your ladyship and the tribunal by having full regard to the pleadings. And this is also what your ladyship's brother, His Honorable Lordship, Mr. Justice Extian, said in that Eastern Cape Department of Correctional Services matter. He said that. It's on the pleadings. So it's not as if we're raising something that is remotely impossible. No, this is something that's well within the realms of what can be done and has been done before. Now, lady, let us go back to the issue of prescription, and I need to deal with what Mr. Fouchier has said, and also address the issue that your ladyship raised initially with me. Lady, on the issue of prescription, and now what has become clear out of Mr. Fouchier's submissions, Kunene, the money was not yet paid. The claims in question here, the money has been paid. And if that is indeed so, lady, neither viva voce evidence nor documentary evidence is required. Because what it points to is the fact that the second and third plaintiffs were, as Judges Moseneke, Bertelsmann, and Derksen said, they're willfully in default. And if they were in willful default, lady, then it cannot be that even at this juncture, where they have again, even, and this time around, even with the first plaintiff, gone now further in the willful default by not bringing the declarator, asking your ladyship for a declarator, because they should have done that even here, so that your ladyship's discretion in favor of declaring my client's conduct unlawful could be triggered. They've not done that. They've not done that, because that declarator of legal invalidity would have then enabled them to assert a claim against my client, even if, rather, if there was indeed a claim to be asserted. So the problem or the additional problem they sit with is this, that willful default of theirs, if they had attempted to address it here before, they had attempted to seek a declarator, again, your ladyship was going to sit with the following problems. Lady, given the sums of money they want out of my client, right? And the fact that my client is not the end point of that money, your ladyship was still not going to be able to give them an order recovering the money from my client. And they can't even say to your ladyship that the forfeiture order with regard to my client's pension would have been sufficient for them to draw from that, because again, my client's pension comes from his monthly contributions over the 19 or 18-year period. He was gainfully employed at the state attorney's office. It's not from the proceeds of crime to the point where it could be forfeited. And herein lies the problem. These papers, as they said, do not even make out a case for the forfeiture of that pension, which has been frozen for now. So even on that score, lady, with the papers before you, had they sought a declarator, they were still not going to be able.
Well, I don't know if that point is of relevance to me at this. Wouldn't that be an argument for merits rather than dealing with a separation application? I don't need to go that far, surely.
Convenience.
Well, I don't know. Not convenience with regard to the merits, convenience with regard to the points taken. Yes, we've got to limit the inquiry at this.
Correct. And given where...
But I think you've exhausted that point. I'm quite sure you've said all you want to on that point.
Yes, I have, lady. And basically what remains, let me just check it for... Oh, I missed one small thing.
Mm-hmm.
My colleague has objected to our Rule 2810 notice.
Well, that doesn't even enter here. That's a separate issue. I don't need to hear that. I haven't seen it. I'm not seized with it.
That's fine. That's fine. Even if your ladyship is not seized with it, lady. Of cardinal importance is that the special pleas that we have raised, there's also the lack of averment to sustain an action, wherein they said that it was the way given how it is couched, it's an exception. The fact of the matter is this, lady. It is there, and in as far as these issues are concerned, lady, I submit that those aspects of the particulars of claim certainly do lack the requisite averments to found and sustain a cause of action. And that point, I've also taken it up in the heads of argument, and I stand by it. So, lady, and then of course, with the issue of costs, my colleague has sought this thing, costs for two counsel, and now I submit the costs for two counsel are not justified. This matter is such that it could have been handled by one of them and not both of them. And the fact that they have elected to do that, lady, and place an additional burden on the fiscus, lady, is their choice. But my client should not be made to pay for two counsel if your ladyship is against us, where there's only a need for one counsel. But then again, in as far as the issue of costs are concerned, costs are not just there to be asked for or to be had, because they are indeed a matter of discretion, lady. And my client is trying to vindicate his constitutionally guaranteed right of putting his side of the story before this honorable court, lady. And given the fact that the money which he could have used to pay for costs is frozen, lady, I would submit that it becomes rather unfair if your ladyship is not with us, to mark my client with a cost order. So, and hence, even where should your ladyship be with us, I've asked that the costs of this application be treated as costs either in the adjudication of the special plea or in the matter of all the issues contained in the plea over on the merits. That is, if your ladyship is with us. And I would submit that such a cost order should also be resorted to even when your ladyship is not with us. However, having said all that, lady, I submit that there is a proper basis from an administrative law point of view, as well as all the other bases resorted to in this application for your ladyship to find it convenient to order the separation. And then we proceed with the special pleas as they are, and then we deal with them in the remaining 2 days, given the fact that we did have these 2 days set aside.
Yes.
So
Thank you, Mr.
those are
Mkambeni. All right, gentlemen, I will obviously have to reserve my judgment. I was hoping that we would be done long before now, but I will attempt to deliver a ruling tomorrow morning. If it's going to be later than 10 o'clock, I will certainly get my clerk to let you know well in advance what time we can hear it. I'll try for 10 o'clock, but you know, things being what they are, if I need a little more time, then we could perhaps start around 11:30 or 12.
That's an order, my lady.
My lady, if I could just seek an indulgence, I don't want to answer on all the new arguments of the defendant in his reply, but I need to draw your ladyship's attention to 2 points, if I may.
You have any objection to that, Mr. Mkambeni?
Yes, I do.
Well, you've raised a lot. You know, you've almost re-argued the points, and I did have to stop you. I don't know what it is in relation to Mr. Fuchsia, but, well, you don't know what it is. What is it that you're objecting to, Mr. Mkambeni?
Well, lady, everything that I argued was in response to what Mr. Fuchsia had argued. It's a simple...
Yeah, well, he raised points which arose from your argument, but then you re-argued in an extended form the points that he had raised, and it didn't strictly stop with a response to what he had said. It went into great expansion, and that's when I had to caution you not to re-argue the matter. I'm going to allow it if you could just tell us what it is that you want to respond to, Mr. Fuchsia.
Thank you, my lady. First of all, the defendant now argues the Constitution, section 239, also defines administrative action. It does not, my lady. 239 defines national legislation, organ of state, and provincial legislation. That's 239 of the Constitution. So it does not confine or define administrative action. That's in PAIA. That I need to address, my lady, or I had to draw your ladyship's attention to. Mm-hmm. The second issue is the Kunene matter, my lady. The Kunene matter was not a review of an administrative action in terms of Section 6 of the PAIA Act for judicial review of administrative action.
PAJA.
Yeah, PAJA, yeah. 3 of 2000. That was not a setting aside or a judicial review thereof. That was a normal rescission application in terms of the common law, my lady. So that definitely did not deal with an administrative action in the Kunene matter. Those are the 2 points that I just had to raise, my lady. I'm not going to argue on the other issues. Obviously, I'll have the should the applicant be successful in the separation issue to deal with the merits of that, my lady.
Thank you.
Just in respect of the costs, we've been to counsel all along in this matter, my lady.
Thank you, Mr. Fuchsia. All right, gentlemen, I'm definitely closing arguments now. No further submissions. Thank you. Yes, I will let you know tomorrow if we can carry on at 10 or a little bit later than that.
Thank you, my lady.
Thank you. Thank you,
As a
court will
court, please.
adjourn.
As of court, please.